Are we already live?
Okay. 3, 2, 1. Good morning, everyone, and thank you for joining the 2021 Virtual County Finance School, the Legalities of Municipal Purchasing and Competitive Bidding. My name is Jeanette Stanziano, and I am the Director of Education and Training for the New York State Association of Counties. Today, we have presenter Mark Stevens from the Office of the State Comptroller, who will be presenting on this important topic. But first, we have a couple of housekeeping messages for you. We will be recording this session, as we always do, and be posting it with a PDF of the slide deck on the NYSEC website after 1:30 today. You can find that under the Education tab, under Finance School, or under Webinars. Also posted today on the website after 1:30 will be the Office of the State Comptroller's form for CPE credits. You only need one form for the entire finance school, as it has a listing of all of the presentations, and you just need to check any presentation that you attended to get CPE credit. You may also visit on your dashboard panel the tab that says Handouts. If you click it, it will drop down, and you will see that you can also download the form right now while the webinar is going on for the CPE credits. We also encourage you to submit written questions at any time during the presentation, so that we may run a Q&A at the end of the program, and we will cover almost all questions that are asked as long as we have the time. So I'd also like to thank our sponsor today, which is Absolute Auctions. For 30 years, Absolute Auction and Realty has been providing New York municipalities professional auction services, finding value in surplus with outstanding results. In REM tax foreclosures, surplus real estate, vehicles, and equipment, today, as always, results matter. And now I have a brief video to share with you from Absolute Auctions.
Hi, I'm Jennifer Gableman, President and Principal Broker of Absolute Auctions and Realty. When putting out your RFP, you shouldn't limit yourself to picking the cheapest company. You should be looking for an auction company with the best package, which should include experience, results, a professional team of licensed real estate agents and auctioneers, and services such as website management, customer service, registration process, closing documents, just to name a few. It's hard to compare a company based off of a proposal, so make sure to contact their long-term references who can attest to their service and give a better understanding of how they work with their clients. Don't forget to include a few important questions, such as, have they ever lost a municipal contract? Or have they ever sued a municipality? This gives you some insight into their professionalism. You also want to see how they adapt to change. For example, in 2020, the whole world changed, and auction companies had to start using online-only auctions. Our company didn't have a learning curve on this, as we've been doing online-only auctions since 2006. For registration, we made it easier by offering it completely online using digitally signed bidding documents. This allowed for touchless registration and for last-minute participation in our auctions. Our results were unparalleled with our competitors. We completed 5 auctions in 6 weeks, had an increased sales from 2019 to 2020 by 123%, had an increase in buyers by 75%, which resulted in 24% higher sales than our competitors. Want more information? Give me a call today.
Thank you, Absolute Auctions, for being our sponsor today. And now I'd like to also thank the Office of the State Comptroller for their support and partnership in the Virtual County Finance School program today. A special thank you to Dan Aquilino for his leadership with coordinating OSC sessions, today of which is one of them. And now I'd like to introduce our speaker for the day, Mark Stevens, Associate Attorney, Office of the State Comptroller, Division of Legal Services. Mr. Stevens works in the Municipal Law and Finance Unit, which is responsible for, among other things, providing legal counsel to the Comptroller's Division of Local Government and School District Accountability, and technical assistance to certain municipal offices of the state on a variety of issues relating to municipal finance. He is giving many presentations to groups of local government officials on the legal requirements of competitive bidding, as well as on conflicts of interest under Article 18 of the General Municipal Law. He has also helped author the memorandum entitled New Piggybacking, Law Exceptions to Competitive Bidding, and the research paper Conflicts of Interest to Municipal Officers and Employees, the Fundamentals of Article 18 of the General Municipal Law. Prior to joining the Municipal Law and Finance Unit, he worked in the Ethics Unit of the Division of Legal Services. While working in that unit, he was responsible for rendering advisory legal opinions and guidance to employees of the Office of the State Comptroller regarding ethics laws, rules, and regulations deriving from the Public Officers Law, the Executive Law, and other relevant sources. Mr. Stevens earned his bachelor's degree from the State University College at Geneseo, his master's from the State University at Albany, and his JD from Syracuse University. It is my pleasure to introduce Mark Stevens.
Thank you very much. I appreciate that introduction. Every time I have the bio read, I understand why my parents thought I was never going to get a job. So in any event, thank you everybody for joining me this morning to discuss competitive bidding. Unfortunately, we can't be together in person, which is I'm used to, but obviously I will certainly do my best to try to walk through the competitive bidding process for municipalities and in particular counties this morning. I also included a couple what I feel are maybe relevant statutory changes that have occurred in the last few years, and I also decided to include a particular Court of Appeals case that I think may be helpful to individuals to be aware of at this presentation as well. So my hope is to kind of walk through the procurement process, go through, again, the statutory sections that I've discussed, talk a little bit about one of the cases, and then certainly, please, I ask if you have any questions, please submit them. I will do my best to try to answer them, and if I can't, I will try to answer them at a later date. So with that said, I'll go ahead and get started. As you can see here from your slide, we're going to primarily discuss General Municipal Law Section 103, but more specifically Article 5A of the General Municipal Law, which basically states that according to the General Municipal Law, all political subdivisions, which would include the county or include counties, are required to competitively bid all purchase contracts and all contracts for public work, which exceed certain monetary thresholds, unless a particular local government has a pre-1953 local law that states otherwise. There are very limited circumstances where perhaps like a city charter or like a village occasionally may not be subject to 103 of the General Municipal Law, but in my experience, I have yet to encounter that. So in any event, the laws we're going to be discussing this morning will be applicable to everyone in the audience. Also, I just mentioned purchase contracts and contracts for public work. I'm going to describe what those are momentarily. Basically, what I would ask is when you try to keep in mind when competitive bidding is required, these dollar thresholds are very relevant. You need to make sure you keep in mind $20,000 for purchase contracts and $35,000 for contracts for public work. These are the amounts that will trigger when competitive bidding is required, unless an exception applies. As you can see below in the next bullet, It does require the awards to the lowest responsible bidder. We'll talk a little bit about what that means later. After advertising for sealed bids. Or in certain cases, you can award a purchase contract on the basis of best value. But again, we'll go ahead and talk about that. Before I go ahead and dive into what the law actually says, I like to include this slide early on to just explain, why do we have competitive bidding laws? What's the relevance of it? First of all, these are kind of what the courts have said with respect to why we have competitive bidding. So to guard against favoritism, improvidence, fraud, and corruption, to foster honest competition in order to obtain the best goods and services at the lowest possible price, and to ensure the prudent and economical use of public monies for the benefit of the taxpayers, and to facilitate the acquisition of goods and services of maximum quality at the lowest possible cost. Now, as you can see, let's just go back, sorry. As you can see from these goals, one of the questions I typically get is, well, I know that there's a competitive bidding law. However, if I save the municipality money, is that going to be a defense for failing to comply with the competitive bidding laws? And the short answer is no, that saving money is not a defense for violating the bidding statute. So there was a Court of Appeals case that basically stated, and I quote, "These separate goals are not incompatible. Favoritism or irregularity in the bidding process may ostensibly produce monetary savings. However, the use of such means to meet that singular end is still unsustainable because the complete public interest is ultimately promoted by fostering honest competition," end of quote. So I do get this with some frequency, a question as to, I want to be able to save my municipality money. If I go ahead and bid, I may end up costing more. Is that going to be a defense? And it is not. So we certainly all want to try to save our local government's money. And I'm certainly not trying to discourage that. My point being, just be mindful that a violation of the statute, even if you're saving money, would be a problem. All right, so now that we've kind of moved on, again, the basic question is, when is competitive bidding required? As I mentioned earlier, there's two monetary thresholds that you need to be aware of. The first one is purchase contracts if they're in excess of $20,000, and contracts for public work if they're in excess of $35,000. Now, these thresholds are set by state statute and can only be changed by the state legislature. So the state legislature has made changes in recent years. Well, I say recent years, now it's been almost 10 years. But it used to be, for example, when I first started, the dollar thresholds were $10,000 for purchase contracts and $20,000 for contracts for public work. So the legislature over the years has increased those dollar thresholds, but it is set by the state legislature. The next question I get is, where are purchase contracts and contracts for public work defined? They are not defined in the General Municipal Law. So if you open up Article 5A of the General Municipal Law, try to look for a definition of a purchase contract or a contract for public work, you will not see that. So we in the Comptroller's office have expressed the opinion that a purchase contract applies to the procurement of commodities, and that the contract for public work applies to contracts for service, labor, or construction. However, it appears that the definition of a purchase contract and a contract for public work for purposes of Section 103 has changed. So what we previously said that a purchase contract included contracts for commodities, and that contracts for public work were for services, labor, or construction. However, we think that in light of a series of statutory changes over the years, that definition of a purchase contract and a contract for public work have changed. I'll give you kind of an example. We're going to talk a little bit about the ability to award best value contracts momentarily. That statute, the statute provides that you can only award for contracts for purchase contracts, not contracts for public work. However, they amended the General Municipal Law to include, for purchase contracts, to include contracts for service work. Therefore, for purposes of awarding a contract based on best value, it appears that contracts for services, other than necessary for the completion of a public works under Article 8 of the labor law, are not categorized as purchase contracts. Let me try to, maybe a better way to do this is just kind of give you some examples to explain. So when you're trying to decide if you have to go out to competitively bid, the first thing you have to do is, do you have a purchase contract or do you have a contract for public work? In the past, I would have told you that if you were going to be contracting, for example, like janitorial or like security contracts, that was a contract for public work. Therefore, if the dollar amount exceeded $35,000, you would have to go out and competitively bid unless an exception applied. However, when the legislature added the ability to award best value for purchase contracts, they specifically listed in their memorandum of law or memorandum of support those services, which would suggest that those are purchase contracts, not contracts for public work. So I realize this can get rather confusing, but I'll leave you with this. This is probably what I say. So you're really only going to run into this problem in one of two circumstances. The first is if you would want to award a contract on the basis of best value. We're going to talk about best value in a little bit. Because the statute only allows you to award best value contracts for purchase contracts, you need to make sure you are in fact awarding a purchase contract, not a contract for public work. The other possibility is when you're in between the dollar thresholds. You're in between $20,000 and $35,000, and you have to decide, okay, do I need to go out and competitively bid? I really don't know. Do I have a purchase contract or a contract for public work? And those are really the only two situations that you're going to run into where you may have to decide whether or not you really have to split hairs as to what exactly you are procuring. My best advice under these circumstances is to consult your municipal attorney, or you can certainly reach out to our office as well. We're happy to provide assistance and guidance on this to address these issues. So what do we know for certain is a purchase contract and a contract for public work? So we still believe that a purchase contract includes your commodities, your goods, your equipment, your supplies, your materials. Contracts for public work certainly still include your building construction. So those still are in play. The real question becomes like if you're contracting for certain services, whether or not that now qualifies as a purchase contract as opposed to a contract for public work. But again, as I said, really only two circumstances where you're going to run into this. One is if you're trying to decide to use the best value award process, or you're in between the $2 thresholds. Okay, I now kind of want to just walk through some of the general rules with respect to competitive bidding that apply and come up with a level of frequency. The first one here, as you can see on your screen, is that purchases of commodities, services, or technology may not be artificially divided for the purpose of satisfying the discretionary buying thresholds. What does this mean? So I'll get the question, Mark, I understand there's a competitive bidding law. You just told me that if I'm over $20,000 for a purchase contract, I have to go out and competitively bid unless an exception applies. Well, maybe what I can do is I'll just split the contract. I'll go ahead and make two contracts both for $10,000. The example I like to use is the purchase of salt. Hopefully we're not buying salt in May, but in any event, the idea is, hey, Mark, I'll just divide the contract into two $10,000 contracts. I'm below the $20,000. Great, I don't have to go out and competitively bid. Obviously, as you can see from your screen here, the short answer is no. The statute expressly provides you can't artificially divide the contract in order to avoid the competitive bidding laws. Next, thank you. The next question that I get with quite a bit of frequency is trying to determine the aggregate amounts, and what does that mean? So I'll read the slide and then we'll kind of walk through it. When determining whether a purchase is an expenditure within the discretionary threshold amounts, under section 103, the statute says the reasonable expected aggregate amount of all purchases of the same commodities, services, or technology to be made within a 12-month period commencing on the date of the purchase must be considered. Now that's a mouthful, right? What in the world is that all trying to break down? So let me try to walk you through what all of this means. So we talked about the dollar threshold, $20,000 for purchase contracts, $35,000 for contracts for public work. In the course of deciding if you are over those dollar thresholds, you have to determine whether or not you need to aggregate those services. In essence, you have to aggregate what is the same commodities, services, or technology. It used to be, we would say that you look at your budget, and if you purchase over the course of a fiscal year in excess of that dollar threshold, so in excess, for example, 20,000, we'll continue with the salt example. So if you look over the course of the fiscal year, you see that you purchase in excess of $20,000 of salt, you are required to aggregate those and therefore competitively bid, even if you're below that dollar amount for that particular contract. In essence, so let's say you only need to buy $6,000 worth of salt in one particular month, but you know over the course of the fiscal year, you exceed the $20,000. You would still have to go out and competitively bid for that $6,000 because you have to aggregate that purchase. Now, I mentioned fiscal year. The statute was amended, and now it requires that you look at a 12-month period commencing on the date of the purchase. So now it's kind of like a rolling basis. In other words, rather than looking at your budget, seeing what you spend for the course of the fiscal year on that item, you kind of have to just kind of set a date and look back 12 months and see if you're exceeding that dollar amount. If you are exceeding that dollar amount, meaning the 20,000, you would have, again, we'd have to go out and competitively bid. The other question I often get is, okay, what is the same commodity, services, or technology? We at the Comptroller's office have, over the years, said if something is same or substantially similar, you need to go ahead and aggregate for purposes of the purchase. So again, this is a question that I get with quite a bit of frequency. Do we need to aggregate, and when do we need to aggregate for competitive bidding purposes? What I can say is I'm more than happy to be of assistance. If anybody in the audience has any questions, at the end of this PowerPoint is our contact information. You're more than welcome to reach out, and we'll be happy to provide assistance. The only thing else I also want to just mention is the statute also provides that a change to or a renewal of the discretionary purchase, meaning the dollar amount, shall not be permitted if the change or renewal would bring the reasonably expected aggregate amount of all purchases of the same commodity, services, or technology from the same provider within that 12-month period commencing on the date of the first purchase, an amount greater than the discretionary threshold. So again, basically what all this says is that if there's a change or renewal to your contract that would get you over to needing to go out to competitively bid, you have to be mindful of that as well. So again, I get a lot of questions about aggregating. When do I need to aggregate? When do I not have to aggregate? Reach out to your municipal attorney, or again, we are certainly available to provide assistance. The third kind of general rule, as you can see here, is bids requirements apply to direct and indirect expenditures. What does this basically mean? Basically, the competitive bidding requirements are not only based on cash that changes hand, but also in-kind considerations such as trade-ins. Therefore, for example, if you have a situation in which you are being provided a trade-in allowance, for purposes of determining a dollar threshold, you have to treat that trade-in allowance as an expenditure. I'll give you the example that I like to use the most. So let's say you need to purchase a new vehicle and the cost of the vehicle is $45,000. The dealer comes to you and says, I know that the dollar threshold for bidding is $20,000. If I offer you, $30,000 for a trade-in, you'll say, great. That means I only have to provide the dealer $15,000 in cash. He's think, oh, I'm below the dollar threshold, and the answer is no. You have to treat that trade-in as an expenditure for purposes of competitive bidding. In essence, you're still over the dollar threshold, therefore you would have to go out and bid. That's not to say the vendor couldn't go ahead and bid, and you can get the trade-in, but it doesn't alleviate from the bidding process. And then last but not least here, it's a question about the source of the money. Unless otherwise provided by law, the source of money to be spent does not alter requirements for competitive bidding. For example, whether you receive state aid, federal aid, or gifts, which brings me kind of to one point here. I know I looked into the coronavirus local fiscal recovery fund. I know I was asked some questions about this. As best I can tell, when you receive those monies, I didn't see anything in the law that would prohibit or would eliminate the need to go out and still competitively bid. So despite receiving those funds, basically the general rule is once the municipality receives those funds, they become municipal monies subject to the competitive bidding laws unless there's an exception. So as you can see here on your slide, unless provided somewhere in the law, the source of the money to be spent does not alter the requirements for competitive bidding. Okay, next slide. All right. As promised, I thought I would kind of talk a little bit about best value. We mentioned it earlier, and it may have caused a little bit of confusion if you've never heard of this before. So I'll try to kind of walk through as best I can. So before I get into talking about best value awards, I want to be very clear. In general, the statute provides that if you're over the statutory dollar thresholds, you're required to go out and competitively bid and award to the lowest responsible bidder, unless an exception applies. However, around 2012, the legislature made an amendment to the General Municipal Law, as you can see here, which provides as an alternative to awarding to the lowest responsible bidder awards, purchase contracts. Again, only purchase contracts, not contracts for public work, may be awarded on the basis of best value, which is defined in section 163 of the state finance law, to a responsive and responsible offeror. Okay, slide, please. So what is best value? Best value is defined in the state finance law as the basis for awarding contracts for services to the offer which optimizes quality, cost, and efficiency among responsive and responsible offerors. Such basis shall reflect, wherever possible, objective and quantifiable analysis. Also below, you can see there are other couple factors that may be relevant, but the general idea is that you can use, in essence, non-price factors may be considered when awarding the purchase contract. So what are some examples of non-price factors? This is by no means an exhaustive list, but I can kind of just lay it out. So they can include reliability of a product, efficiency of operation, difficulty or ease of maintenance, useful lifespan, ability to meet needs regarding timeliness of performance, and experience of a service provider with respect to similar contracts. Again, in other words, when you award a contract on the basis of lowest responsible bidder, what happens is you go out, you competitively bid, you receive bids, you look at the dollar amounts, whoever has the lowest dollar amount for that bid receives the award if they're found to be a responsible bidder. We'll talk about responsibility a little bit later. With best value, you can look at non-price factors, in essence, when you're doing the award for the purchase contract. However, with that said, please note that the statute also states that the basis for a best value award must reflect, wherever possible, objective and quantifiable analysis. Therefore, in evaluating and determining to accept a higher priced offer because it optimizes quality, cost, and efficiency, the local government should generally demonstrate by a cost-benefit analysis quantifiable value or savings derived from non-price factors that offset the price differential of the lower price offer. So in essence, you should do what's called a cost-benefit analysis. So I believe we can do next slide. Thank you. Before I kind of give it, I kind of put an example in here to help explain. So before we get into that, if you at the local government are interested in using a best value award, the first requirement of the statute is that you have to first authorized by local law. So I don't know, depending on what county you are, it's possible you've already gone ahead and passed a local law allowing for the use of best value. One of the questions I got early on was, do you have to pass a local law every time you want to use the best value award? And the answer is we don't think so. We think you can just have one local law that indicates that the county can go ahead and use best value as an option for awarding purchase contracts. So that's important. However, keep in mind, you have to also make sure that the best value statute provides that the offeror needs to be responsive and responsible. So for purposes of best value, we believe a responsive offeror is an offeror meeting the minimum specifications. So similar to how you would have bid specifications when you go out to competitively bid, you have to have some criteria for how you would go about awarding a best value award. As for responsibility, this is a factual case-by-case examination into a vendor's background, subject to due process protections, assessing factors such as a bidder's capacity and financial ability to complete the contract, accountability, past performance, reliability, and integrity. Okay, we can go ahead and do slide, thank you. All right, as promised, I think the best way to try to explain how you go about awarding a best value award is kind of an example here. So I kind of included an example here. So here you can see a local government solicits competitive offers to purchase a new pickup truck. So you have two vendors who submit an offer to the local government. One submits an offer for $40,000, but vendor B offers a more fuel efficient truck at a price of $45,000. So normally, if you're awarding to the lowest responsible bidder, you look at the two amounts, $40,000 versus 45, assuming both vendors are responsible, you would award the contract to vendor A. How does best value kind of change that analysis? Well, you can see here in my example, you do conclude that both vendors are responsible and responsive, but you also found that the local government reasonable estimate its average annual fuel cost to be about $4,000 for vendor A's truck and $3,000 for vendor B's truck. You also conclude, based on a reliable independent studies, that it's likely that you're going to have less maintenance costs with vendor B's vehicle as opposed to vendor A's vehicle. Here again, assuming maintenance costs of $1,000 annually for vendor A's truck. Based on this, the local government determines the expected useful life of a new truck to be about 10 years and intends to retain the truck for the full useful life. Slide. Oh, slide, please. So here you can kind of go, in order to qualify, quantify these other specific aspects relating to the new pickup truck, I kind of broke it down. So the truck price for vendor A is $40,000, for vendor B it's $45,000. However, once you start factoring in the costs of fuel and maintenance, you can see that the total cost for vendor A's vehicle will exceed the cost of vendor B's. So based on this analysis, it may be possible that the local government can support a determination that the truck from vendor B provides, quote unquote, the best value to the local government. So again, this was trying to give you an example of what a best, where even though the vendor who submitted the higher priced offer might ultimately be the best value. I'll just mention a couple things before we jump into exceptions. Just be aware the statute still requires, whether you do competitive bidding or awarding on the basis of best value, you still have to publicly advertise for the bidder offer and have an opening requirement. I know there was a suspension in light of coronavirus for having public bid openings, so I keep that in mind. But when hopefully things get back to normal, you will have to have that public opening for both. What I've basically been advising local governments, as long as I'm talking about this, what I've been advising local governments is, in the interim, if you are capable of doing some sort of virtual bid or offering opening available to the public, or at least can record it, we would recommend it just to help provide some sort of insight into the opening process. All right. I should mention again, I know I'm speaking quite a bit. I don't know if there'll be any, I've been doing a lot of material here. I know there may be questions. Normally I'd open this up to questions if we were in person. I will again try to be helpful and answer questions. So please submit your questions. I'll do my best to answer them at the end. Next section I wanted to discuss was certain exceptions to competitive bidding, right? So we talked about when competitive bidding is required. You're over the dollar thresholds, $20,000 for purchase contracts, $35,000 for contracts for public word. If you're over those dollar thresholds, you are required to go out and competitively bid unless an exception applies. So this next section is just kind of walking you through what are some of the more common exceptions. I'm not going to go into great detail with every one of them, as I want to make sure I leave a little bit of time for questions, but I wanted to at least touch on some of them. The first one is, it's quite common, is the emergency exception. You can see here the statute requires that you have 3 criteria that need to be met. First, that has to arise from an accident or unforeseen occurrence or condition, affects public buildings, property, or life, health, or safety, and an immediate action is needed and cannot await competitive bidding. The example that I like to use typically is like a bridge washes out in the middle of the night, or a road buckles, a huge sinkhole threatens the elementary school, for example, something that needs to be immediately resolved. However, an emergency, it's not an emergency if the situation arises as a result of inaction, lack of planning, or dilatory behavior on the part of local officials, or if there is time to comply with competitive bidding. So an example, occasionally I'll get a call, you know, does the emergency exception apply? We want to do a repair in the next 6 months. As you can see here, I would say that that's probably not an emergency if you have time to go out and competitively bid under those circumstances. Next exception is surplus or secondhand equipment. This is a statutory exception to competitive bidding with respect to the purchase of surplus or secondhand equipment, supplies, or materials from the federal government, state government, or any other political subdivision or public benefit corporation within the state. I do want to just caution everybody, however, that unlike the exception I'm going to talk about a little bit later with piggybacking on other governmental contracts, we at the OC don't believe that this exception extends to state or political subdivisions outside of New York State. So we have on audit occasionally run into a situation where a local government has thought they could use this exception to buy surplus or secondhand equipment from an out-of-state entity, and the way the statute is written, we don't think that that would apply. It has to be within New York State. Also, just be careful, there is no exception for purchases from private sources. So again, make sure it's you know, the federal government, another state government, another political subdivision, or another public benefit corporation within the state. Slide, please. Thank you. Next exception, which comes up with quite a bit of frequency, is the professional services exception. Unlike the 2 exceptions I just discussed, this one is not set forth in the statute. It's created by case law. In essence, the courts have based the rationale that certain services are not the type of public work which can be measured by the objective uniform standards of a bid specification, with a contract being awarded to the lowest competitive bidder. With some contracts, factors other than price should be considered. What are these determinations? These include typically the application of specialized skill, training, or expertise, the use of professional judgment or discretion, or a high degree of creativity in the performance of the contract. So I'm sure most, if not all, of the audience members have used the professional service as an exception to competitive bidding. Some of the more common exceptions that we see are the services of an engineer, contracts with a land surveyor or a physician or attorney, placing of insurance coverage and services of an insurance broker, services of a court stenographer, preparation of plans or specifications by an architect, contracts for fire protection or ambulance service, a management contract for a municipality-owned stadium, and contracts for pharmaceutical services, and paratransit transportation is one of the. So we have an opinion, the State Comptroller's opinion 2007 #1. It's available on our website, which discusses that the use of a paratransit transportation contract would qualify as a professional service. So again, these are where specialized skill or training is necessary, and therefore competitive bidding is not required. It's quite common to enter into professional service contracts as an exception to competitive bidding. Next slide. Another rather frequent exception that we run into are what I refer to as true leases or licenses. True lease agreements, they're neither purchase contracts or contracts for public work for purposes of the General Municipal Law, and therefore are not subject to competitive bidding rules. However, they are subject to your own procurement policies and procedures under 104B of the General Municipal Law. We'll touch on that at the end. So why do I say a true lease? Because you can't avoid competitive bidding simply by casting as a lease an agreement which truly is a purchase or a contract for public work. So for example, just because at the top of the document it says lease does not make it so. Rather, the total character of the agreement determines if it indeed is a lease. So let me give you some examples, some characteristics which suggest that the agreement is not a lease. If the intent to transfer title is with the political subdivision, that would be suggestive that you're not entering into a lease. If the political subdivision assumes incident of ownership, such as risk of loss, responsibility for maintenance and repair, or the obligation to secure insurance, or the amount paid by your professional subdivision exceeds the fair market rental. Those are all examples of where you may not be actually entering into a quote-unquote true lease. Also, be careful. There are circumstances where you may be entering into what's called an installment purchase contract, which is set forth in section 109B of the General Municipal Law. We don't have time this morning to talk about purchase contracts. Statutory installment purchase contracts, but that section does require that you go out and competitively bid if you enter into such an agreement. So my best advice, if you're thinking about entering into a true lease or license, is we recommend that you consult with your municipal attorney before entering into it. And as always, as I continue to repeat, please don't hesitate to reach out to us as well should you need any assistance. So the next exception I'd like to touch is the sole source exception. Before I get into it, I just want to caution everyone, this is a very limited exception. It's also not statutory, but it's allowed for in situations in where there is only one possible source from which to procure goods and services, and those goods or services are needed in the public interest, in which case competitive bidding is not required. In the past, examples of this would include services provided by public utilities where they have a monopoly, but in light of deregulation of electricity and things of that nature, that's not so much an issue today as it used to be. But you should be prepared to justify a sole source procurement by showing that the item uniquely serves the public interest. There's no other product that provides substantially the same benefits, and that considering those benefits, the cost of the item is reasonable. And lastly, the item is available only from one source and no substantial equivalent. We're not going to have an opportunity today to talk about the actual competitive bidding, like the procedures, but you want to make sure that you're not drafting your bid specifications so restrictively that you create your own sole source. So the example that maybe would be the example is if you were trying to purchase a vehicle and you chose to include your vehicle identification number in the bid specifications. Obviously, that would be too restrictive of a bid spec and would be creating a sole source. So you can't create your own sole source by virtue of drafting your bid specs so narrowly that only so these qualities apply. Okay, next slide, please. The next exception I'd like to discuss is preferred sources. I'm sure many of you are familiar with this. Oh, okay, yeah. Next slide, please. Oh, other direction, please. No, yep, sorry, other way, yep. One more, please. Thank you. So again, preferred sources, this is found in State Finance Law Section 162. It basically provides that you must purchase from preferred sources under this section if it meets the same form, function, and utility required. So OGS maintains a list of available preferred source commodities. As you can see here on the slide, I've listed those entities in which you need to purchase if they are offering the item. If they are offering the item in the same form, function, and utility, the statute does provide that you're required to purchase from these entities. So if you have further questions about awarding a contract for preferred sources, again, reach out to our office, or New York State Office of General Services also can likely provide you assistance on this. Next slide, please. Now we're going to kind of get into the piggybacking with respect to when I say piggybacking, the ability to purchase off of other governmental entity contracts. The first one I'm going to start with, obviously, is being able to piggyback off of county contracts. This exception is found in 103 subdivision 3 and basically allows local governments to take advantage of other county contracts, provided the county has gone ahead and extended those contracts to local governments. So I'm not sure how many counties in the audience extend their contracts to other local governments, but this certainly is a rather popular exception that can be used. Prior to 2011, you could not extend the contracts under Article 8 of the labor law, which was public work. But as you can see here on your slide, they have just recently extended, they being the legislature, allowing for extension of contracts under Article 8 of the labor law until July 31st, 2024. However, the restriction on services governed by the prevailing wage requirements of Article 9 of the labor law relating to building services employees remains in place. So in other words, the contracts can be extended for Article 8 of the labor law contracts, but not Article 9. Next slide, please. Another example here, certain state OGS contracts. Certainly, I'm sure many people are familiar, under Section 104, political subdivisions are allowed to make purchases through the New York State Office of General Services. In essence, OGS puts together a list of state contracts with a provision that extends the contract to local governments and what kind of goods and services can purchase each year. You as the county would purchase from the state contract vendor and pay that vendor directly. However, any purchase you make must be made with the same terms and conditions that are contained in the contract between OGS and the contractor. Also, you may not purchase from an OGS contract if you have already received bids, unless the purchase can be made on the same terms, conditions, and specifications, but at a lower price. Another question that I often get is the phrase OGS or less. In essence, what this means is sometimes vendors will be aware of the state OGS contract price. They'll come to you and say, look, I can beat the state contract price, don't go out and competitively bid. The short answer is that is not an exception, and the policy behind it is that if one vendor can beat the state contract price, it's possible that other vendors could as well. So again, a word of caution from our end when we do audits, you want to make sure that the contract or the vendor you're purchasing from does in fact have a current state OGS contract, and that sometimes what we find is that the vendor no longer maintains that contract, or alternatively, someone tries to beat the state contract price and has never been awarded that contract. So just a word of caution when using this exception. Next slide, please. Just kind of a continuation. In addition to purchasing from certain state OGS contracts, Section 104 was amended several years ago to also authorize political subdivisions as an exception to competitive bidding to make purchases through the Office of General Services or any other department or agency of the state, subject to rules promulgated pursuant to Article 11 of the state finance law. I don't know if there have been any regulations established yet, but basically what this allows is local governments can piggyback off of other department or agencies of the state However, whether or not these departments or agencies are in fact extending the contracts, I'm not sure if that has taken place or not, but just want to be let everyone in the audience be aware that that has also was extended now to July 31st, 2024. All right, moving right along. I'm just looking at the time here. I want to make sure I leave some time for questions. In addition to county contracts, state contracts, there are exceptions. You can purchase off certain federal contracts. Since people will have the handout, I'm not going to go through each one of these, but in essence, the General Municipal Law allows for a series of different federal contracts that local governments can go ahead and piggyback off of. What you need to do under these circumstances is make sure you follow the regulations of the federal GSA. So for example, there's like Supply Schedule 70, Section 1122 of the National Defense Authorization Act. But in essence, you can go ahead and piggyback off of certain federal contracts. Next slide. Again, these are just a list of what you can go ahead and piggyback off. Make sure you are, in fact, using one of the listed contracts. It's not been extended to every single contract available to local governments, so there may be one. So make sure you consult with your attorney before you go ahead and piggyback off of a federal contract if you're going to use it as an exception to competitive bidding. This also has been extended to July 31st of 2024. Next slide. I won't spend a terrible amount of time on this, only because we do have a handout available on our website, but perhaps one of the most used exceptions now is what I refer to as certain other governmental contracts, which added a subsection 16 to General Section 103. It basically allows political subdivisions to purchase apparatus, materials, equipment, or supplies, or to contract for services related to the installation, maintenance, or repair of apparatus, materials, equipment, and supplies as may be required by such political subdivision or district therein for the use of a contract let by the United States or any agency thereof. As you can see here, you have to make sure that the contract was awarded to the lowest responsible bidder or on the basis of best value in a manner consistent with this section and made available for use by other governmental entities. The legislature just recently extended this exception to July 31st, 2023. Next slide. So I did want to just kind of briefly go through, however, what those requirements are in order to be able to use exception. So the statute does provide certain prerequisites that need to be met in order for you to be able to use this exception. The first one is the contract must have been let by the United States or any agency thereof, any state or any other political subdivision or district therein. So in other words, if you wish to go ahead and use this as an exception, the first thing I always recommend is get a copy of the contract itself that you wish to piggyback and confirm that it is in fact a local government, or I'm sorry, that it is a governmental contract and not like a private party or something along those natures. All right, next slide, please. Secondly, the contract must have been made available for use by other governmental entities. In other words, this prerequisite is satisfied by inclusion in the contract let by the other entity of a clause extending the terms and conditions of the contract. So like I mentioned with county contracts or OGS contracts, you have to make sure that the contract has in fact been extended to local governments. As you can see here, unilateral offers by vendors to extend the contract would not be allowed. Next slide, please. Also, the contract must have been let to the lowest responsible bidder or on the basis of best value in a manner consistent with this section. Basically, what we've said is that the term consistent with this section refers to Section 103 of the General Municipal Law, and the purchasing local government would need to obtain background information on the procedures used to let the contract and as necessary consult with your counsel to determine whether this prerequisite is met. So what are some of these factors? So next slide, please. So as you can see here, in order for a non-New York contract to have been let to the lowest responsible bidder or on the basis of best value, you have to make sure it doesn't have to be exactly like the procedures in your in Section 103 of the General Law, but you want to be fairly close. So again, next slide. So what do we think you need to be able to show in order for a determination that you can use the exception. So the first one is you need to see that there was some sort of public solicitation of bids, or in the case of best value and offer, that there was a sealed bid or offer process or some sort of analogous procedure. There was preparation of specifications or some similar document, as well as there needed to be the award to the lowest bidder or some sort of best value type process. So I'll tell you where we find local governments get tripped up. The first one is you want to see how the contract was actually awarded. If there was, for example, like a negotiation process as opposed to awarding on the basis of best value or lowest responsible bidder, we've said that could certainly be an issue. So the other thing we've found on audit is that you want to make sure that you are actually doing your due diligence before going ahead and awarding this or using this exception. And what I mean by that is you don't want to just assume that this exception applies. Make sure you get a copy of the contract, document why your local government believes that each of the prerequisites are met. So if we were on audit, we have some sort of documentation to show why you believe this exception applies. This will be very helpful for us to make sure that there was some sort of analysis done prior to just using the exception and not just blindly saying that you were told that you could go ahead and use that exception. So again, we strongly recommend that you go ahead and do that. Also, next slide, please. Other factors you may want to just keep in mind, the one that I'll talk about, again, we talked about documentation, the importance of documentation. Also, don't assume that using these contracts will necessarily be will save you money. Although the statute doesn't require you to do a cost savings justification, we recommend it here at OC to do some sort of cost analysis to make sure you are in fact getting the best price for whatever you are looking to purchase. In many cases, you very well may be able to, but there could obviously be circumstances where that is not the case. All right, next slide. Just kind of one last thing here, whether lower may make purchases that are below the status. So this question is like, if you're below the dollar threshold for competitive bidding, can you still use this exception? The answer is yes, but we recommend that you amend your procurement policies to include that exception. So we at the OC, we have a document called in our local government management guide. It's called Seeking Competition in Procurement. It is available. If anyone has trouble finding it, feel free to reach out to our office. I'll be happy to show you where it is. And in the back of that document, we kind of have a sample procurement policies and procedures, and there we list where we think it would be important to add this to your procurement policy to make sure that it is permitted that you go ahead and can use this exception. Next slide. Okay, we made it through. I know we only have about 10 more minutes. I wanted to make sure I just touch on a couple quick things. We didn't really get into your own procurement policies and procedures. If anyone has questions about that, again, unfortunately, with limited amount of time, I didn't get a chance to talk about it. I'm happy to discuss that, but I wanted to just quickly touch on a couple things here that have occurred over the last 3 or 4 years. The first one, as you can see here, purchases through the county contracts by certain not-for-profit corporations. And then there's the reciprocity of debarment, and finally, authority for counties to purchase certain food products. So I'll just touch on the last one first, actually. So there was a new section 9A of GML 103, which was added in 2017. Basically, it authorizes a county in certain circumstances to purchase eggs, livestock, fish, dairy products, juice, grain, and species of fresh fruit directly from New York State producers or growers, or certain associations of producers and growers. You can go ahead and, as an exception to competitive bidding, right now you have to make sure that you adhere to your own procurement policies with respect to using this contract or going ahead and using this as an exception. But I just wanted to point out this exception used to only apply to school districts, but again in 2017, and then they made a series of amendments. Now counties can also go ahead and use this. So if anyone has any questions or wants to know more about how you would go about using this exception, I listed the laws, and again, as I keep repeating throughout the presentation, please don't hesitate to reach out to us. Reciprocity of debarment, I really don't want to get into it too much because I am running out of time. I want to make sure a few minutes for questions. Basically, there was a law that added new sections to the labor law as well as the General Municipal Law, which provides that if a vendor is been debarred by federal contracts, and I'm paraphrasing here, that they are not permitted to submit a bid to local governments as well. So again, if anyone has any questions, please feel free to reach out and I'll be happy to assist. And again, I added this. I knew I wasn't going to have time to speak on everything, but just to be aware, the GML was amended by adding a new section 109C to allow not-for-profit corporations that provide a service to a county to make certain purchases or to contract for services through the county with which the not-for-profit has a contract. There's provisions the county can establish limitations with respect to this and so if any county is interested in this or wants to know more about it, again, I just want to bring this to everyone's attention that this came into existence. Again, now it's 2016, so it's almost 5 years old, but wanted to at least touch base. And then I want to make sure I leave a few minutes for questions. So we'll just do the last slide here. Which I just wanted, the reason I like to bring this case up to everyone's attention, only because I think it's very relevant even today. So basically the question that came up over the years is when you go out and competitively bid and you have to draft your bid specifications, the courts have said you can't deviate from your bids, materially deviate from your bid specifications. If you do so, it's a violation of the bidding laws. The question that always came up though was, well, okay, I don't have to go out and competitively bid because either there's an exception applies or we're below the thresholds or, for example, like a professional service, and we go ahead instead and do like a request for proposals. How far can we deviate from what we listed in our proposal? And there was a series of court cases over the years, some saying because competitive bidding is not required, you can deviate from your proposal. There was other court cases that said, no, you need to make sure that you don't deviate. So this was a Court of Appeals case that came down in 2017, which kind of ultimately cleared up the issue. Again, I don't have time this morning to kind of go through all the facts, but in essence, the court addressed whether evaluation criteria for public bids submitted under your procurement policies must be followed as set forth in your request for proposals, or if the criteria may be changed after the receipt of proposals by the government entity responsible for evaluating the proposals. And the majority of the court held that the county in this case, Orange County, deviated from the criteria specified in its RFP when it evaluated the proposals and instead created a new formula. So in essence, what happened was there was a deviation with how points were going to be allowed for evaluating and approving the RFP, and the court ultimately concluded that that an award of a contract under Section 104B, again, your procurement policies, is arbitrary and capricious if the municipality evaluates a proposal using a standard that deviates from a standard expressly set forth in the request for proposals. Such a deviation betrays a lack of, quote, sound basis and reason for the determination, end of quote. So the reason I bring this to everyone's attention, and I think it's one of the more important cases that have come down in the last few years, is that whether you're going out and competitively bidding or you are doing a request for proposals, the courts have made it clear now that you cannot deviate from your criteria with respect to awarding the contract. If you deviate, the courts will nullify the contract. In essence, if you find, and the court went on to say, if you think that you need to make a change, you need to go ahead and reissue the request for proposals. So with that said, I know I didn't leave a ton of time for questions, but I wanted to make sure I did leave at least a few minutes. And because I know I'm not going to have time to answer a question if there are any, please, this is our resources, this is our contact number, this is our general number. Please feel free to leave a message and I will do my best to answer your questions. So with that said, I wanted to make sure, I don't know if there are any, I'm just kind of open now.
Thank you, Mark. Yes, there are a number of questions that I'd like to pass by you for a response. The first one is, can you try again to define public works contract. Here's
Sure.
an example. Park lot ceiling / striping, not part of a building capital project, between 20 and 30K in a 12-month period.
All right, I'm sorry, can you repeat the example again?
Yes. Can you try again to define public works contracts? Here's an example. Parking lot ceiling / striping / not part of building capital project, between 20 and 30K in a 12-month period.
Sure. So I'll start out by saying, so it is a little bit more tricky with respect to trying to decide if you have a purchase contract or a contract for public work. So basically what we have concluded now in light of the series of statutory changes over the years is that a purchase contract still includes your commodities, your goods, your equipment, your supplies, materials, and contracts for public work would be your building construction. So obviously the example that was provided here is what type of service is this? So what I recommend under these circumstances, you kind of have to look at the totality of all the work, and are you really paying for like the materials relating to the striping, or are you really paying for the labor? If you're my best guess is if you're in between the dollar thresholds here, and you're not really sure, whether or not, if you're paying primarily for the materials and the supplies, I would argue that's a purchase contract. If you're paying more kind of for the labor aspect of it, I would argue that's a contract for public work. In my personal view, where you're in this type of situation, because I know the question said you're in between the dollar thresholds, I think the safer approach is to go ahead and competitively bid, just to avoid any potential issues. But again, it is a case-by-case basis, and what I do is I look at the totality of the circumstances and really kind of see what you're procuring. And if it's closer to the materials and supplies part, then you could argue it's a purchase contract. If it's more in line with, a public, the service fee, the labor, you could argue it's a contract for public work. But unfortunately, because they've blurred the lines of what is a service, I think certain services may qualify as a purchase contract, and therefore I think the safer approach in this particular example would be to go out and bid, just in case anyone were to challenge it and argue that it is a purchase contract. So that's my general recommendation.
Thank you. So here's question 2. Can a vendor from the municipality be considered as one of the factors in best value awarding?
I'm sorry, can you repeat that again?
Can a vendor from the municipality be considered as one of the factors in a best value award?
Yeah, I apologize for whoever submitted this request. I'm not really sure what we're going at. I mean, so in essence,
Mark, this is Steve Aquario. I think that perhaps the question is, can a local preference be considered a factor?
Oh, a local preference. Thank you. Okay. Thank you, Steve. So the short answer is, when awarding a contract for competitive bidding, a local preference is not permitted. So please be careful. I know that question comes up with quite a bit of frequency. As for where a contract is not subject to competitive bidding, there is a lower court case that concluded that a local preference could be used. I personally think, I'll be honest with you, this is my personal opinion, is that I'm surprised that that case went that direction, but there is a lower court case that concluded that a local preference could be used when competitive bidding is not required. So the question here is, what about best value? I personally think the safer course of action is to not use a local preference. Certainly you can't for competitive bidding. I would highly recommend not doing it, even when competitive bidding is not applicable.
Thank you. The next question is, auctioneer services are unique in the way commission is paid by the purchaser on sales with no direct cost to the municipality. Should this work be contracted as a professional service and not subject to General Municipal Law 103?
Well, I know we get, occasionally questions about auctioning services, and it's really going to be case specific as to what services they are being provided, whether or not it would qualify as a professional service and it's not subject to competitive bidding. But I would point out, even if you got comfortable that the competitive bidding requirements of 103 were not applicable, our office would recommend that you still do some sort of competitive process pursuant to your procurement policies before awarding just professional services in general. So as you'll see from a series of documents we've put out over the years, we recommend that you do a periodic competitive process, whether that be a request for proposals, request for quotes, some sort of competitive process periodically when awarding professional service contracts, and that you don't just never do any type of competitive process when awarding professional services. So again, it's possible it could qualify as a professional service, but even so, we would recommend periodically doing some sort of competitive process.
Thank you. So the next question, where does environmental impact come into play with your example? I don't know if that's out of order, but it might have been from the earlier question, but where does environmental...
Well, I'm wondering, I do get this question periodically with respect to awarding best value and whether or not you can use best, when you're using non-price factors, is the environmental impact one of the factors that you can use? That's my best guess for what this question is. If I'm wrong, please, feel free to reach out and we can talk. What I would say is, while it can be a factor, I would not rely on it as the only factor with respect to awarding a best value award. Again, you have to be able to justify why a higher priced offer should be awarded. And my guess, I don't think it's ever been litigated, but my guess is that a court would conclude that environmental impact in and of itself would probably not be enough to argue that that's the best value. Again, I know no one wants to be the test case for that, but that's my general guess.
Thank you. So here's another question. Is a technology contract such as red light camera for speeding, which seems to be public work contracts for a service, subject to competitive bid, and the contract doesn't cost the government any money, but rather generates money to the government?
So I know there's, I know a lot of local governments are contracting for these type of services. I'm not terribly familiar. Again, these are very fact specific. If I understand correctly, the way it works is there is no expenditure on the part of the local government, but in essence, I'm guessing what happens is you enter into like a long-term license or some sort of lease agreement where the entity provides the equipment and in return they get a portion of the proceeds. In which case, it may be possible that it qualifies as the exception for a license or lease. I'm not familiar enough with these particular programs, so it may not be that they are a purchase contract or a contract for public work. It may be that in essence they're something else. So whoever asked this question, I'm more than happy to look into it with more detail, but that's my thoughts.
Okay, great. What are the rules regarding length of contracts? For example, awarding a service contract based on best value, how long can or should term of contract be? For what about term of contract extensions? Okay,
sure. So this question does come up kind of with some frequency. How long can our contracts be? I'm going to try to answer it. It's a lot. There's a lot to consider, but the short answer is you don't want to have a contract that's that extends indefinitely. So we've said that while you can include in, for example, like a bid document that an option to renew, sometimes you'll see an option to renew for several years. Either party can choose to renew the contract, but where the local government would get themselves in trouble is a situation where the contract just automatically renews and there's no end date. And then that said, kind of just as a general rule, there's no law or anything. I mean, I generally say probably you don't want to do anything longer than 3 or 4 years, maybe 5. You run the risk of there's a common law concept called binding successor governing boards. You don't want to be in a situation where you might be, making the board of one local government binding future boards. But you can have renewal. The short answer is you can have renewals in your contract. You can put it in your bid specification so that when vendors are bidding, they're aware that there will be renewal provisions. But you cannot you can't have a contract that just automatically renews every year. That's when you'll run into problems.
Okay, just a few more. Are subscriptions to software applications considered licenses?
Okay. So we get this question occasionally. It is certainly a possibility. We have an opinion, and please forgive me if I've got the wrong opinion number. I think it's 1988, number 35. I think it's available on OSC's website if you look for legal opinions, and it goes and walks through, although it's from 1988, it's interesting enough, it's still relevant, almost 40 years later. But in essence, it walks through whether or not software would qualify as a professional service exception. It's possible it could qualify as a sole source, or it's possible that it could qualify as a license agreement. And if it is a license agreement, then yes, it would be an exception to competitive bidding. Again, similar to my discussion about professional services, though, I would recommend that you have something in your procurement policies that requires some sort of competitive process periodically, even if you're, for licenses as well. But again, if anyone's interested, the opinion that may be of assistance to them would be 88, number 35. And if I've gotten the opinion wrong, please reach out to me. I'll make sure I track down the correct opinion.
Is the purchase of renewable energy credits, does that fall under purchase contract or part of professional service contracts?
It's been a while since I've looked at this. I believe there are provisions in the public service law that allow for the procurement of certain electricity. And what we've said, at least on audits where we've run into this, for example, with like there's certain, I'm forgetting the name, I apologize, a purchase power agreement is what I'm thinking of, where we've said that qualifies as a professional service. So I would need to know a lot more details about this particular question, but it's possible that what the renewable energy may qualify under the public service law. So whoever submitted this question, please feel free to, if you want to follow up, I'll be happy to provide more assistance.
Can you name any specific agencies that offer certain other government contracts?
Like I said in the presentation, I'm not aware. I know at one time there was a question, I don't want to put New York State Department of Transportation on, there was a question about plow equipment, but again, the short answer is no. I don't know if there are any other governmental entities outside of this Office of General Services that extend their contracts. Basically, the point I wanted to point out was if there is authority for the local government to go ahead and use those contracts. So I haven't heard of any, but it's possible.
And our final question is there an exception to the competitive process for annual licensing costs for applications that have a small part hardware component, but are mostly cloud-based storage and data management?
Again, I think we kind of touched on this with an earlier question. It's certainly a possibility that the service could qualify as a lease or license, which is an exception to competitive bidding. I mean, without knowing the specifics, it's hard for me to reach it. This is just kind of general, but that is a possibility. Again, I know I keep repeating myself, but if whoever submitted the question wants, assistance, I'm happy to feel free to reach out with the number again, and I'm happy to look into it with more detail. But it is a possibility that the licensing exception would be applicable.
Well, Mark, I want to thank you for this insightful presentation. I also want to let you know that under the questions tab, there were not only 1, but 4 notes that said great session and thanking you for the session. So I got to tell you, that's pretty rare. So thank you so much. And you've certainly received a great response from our audience. That's pretty much all staying tuned all the way through. So if anyone would like this program, please look on our website after 1 o'clock today under the Education tab and then under Finance School. Mark, did you have another statement to make?
No, I was just going to say thank you very much. I appreciate everybody taking the time today to listen to this presentation. I want to thank NISAC for giving me the opportunity to present, and hopefully we'll be doing this in person in the future.
Wonderful. And once again, a huge thank you to the Office of the State Comptroller for partnering with NISAC on another county finance school. And actually, this is our second virtual county finance school during the time of COVID. It's nice to know that we've been able to provide CPE credits through OSC to our members, which is invaluable. Thank you so much, everyone, for joining us for this program today, and we hope that you will participate in future NISAC webinars. Thank you so much, and have a great day.
Thank you.